Get ready for a legal dictation. 5 seconds. Start. Therefore, the fact, composite office orders 17/2017 and 19/11/2018 were issued by the Commissioner, makes no difference to the validity of the power exercised, full stop. Non-recital of section 5 within bracket 3 of the Act in either of those orders is inconsequential and even extraneous to the valid exercise of power made by the Commissioner, full stop. The power was admittedly existing and it is seen to have been exercised, full stop. It is not shown to have been exercised in contravention of any statutory provision or principle of law, full stop. Hence, the validity of the power exercised would remain by established firm and undoubted, full stop. Paragraph change. Section 5 under bracket 3 of the Act provides the source of power to be exercised by the Commissioner for the purpose of Section 4. Read with Section 2 within bracket 91 of the Act, full stop. As noted above, the power under Section 5 within bracket 3 of the Act is a general power of subdelegation vested in the Commissioner, by the legislature, full stop. Once that power is shown to exist and the same is seen to have been exercised, no fetters may be searched and attached to the exercise of that power, and no challenge may arise thereto, dehors the statutory scheme, to defeat that exercise of power, full stop. Paragraph change. It is not the requirement of law that the source of power must necessarily be recited in the order passed in exercise of that power to validate the power exercised, full stop. It is enough that the source of power existed and it was exercised in the manner prescribed by law, full stop. Its recital in the order passed in exercise of that power would not lend or add to the legitimacy of the power exercised, full stop. It is not a spell that may cause a magical effect only upon its incantation in a ritualistically correct manner, full stop. Paragraph change. As to the further submission advanced by learned counsel for the petitioner on the strength of Section 6 of the Act, we find, the same is misconceived, full stop. It has no applicability to the present facts, full stop. That provision would apply only to officers appointed under the Central Act, full stop. Those officers may act as proper officers under the Act subject to conditions as the state government may notify in that regard, and not otherwise, full stop. Paragraph change. Thus, the statutory scheme appears to be the legislature has first recognized the Commissioner as the proper officer for all functions under the Act, full stop. It also recognizes the classes of officers who may be appointed officers under the Act, full stop. Further, officers of the UP VAT Act have been recognized as officers under the Act, on deemed basis, full stop. As to the officers of the central government, the state government has been delegated the power under Section 4 within bracket 1 of the Act, bracket close, to appoint them officers under the Act, full stop. Second, as to the functions to be performed by various officers under the Act, the Commissioner may subdelegate absolutely, any functions to an officer of state tax under bracket as defined under Section 2 within bracket 104 of the Act, bracket close, full stop. On the contrary, an office of the central government may not be subdelegated such powers generally, full stop. He may be subdelegated that power and he may act as a proper office subject to that condition at the state government may by notification under Section 6 of the Act, bracket close, specify, in that regard, full stop.